Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within the Commonwealth. Draw near, give attendance, and you shall be heard. Now say the Commonwealth of Massachusetts, court is open, please be seated.
Good morning and welcome to the Appeals Court. I'm William Meade. With me today are Justices Walsh and Hodgens. We'll be the panel in all of the cases. As you know, each side gets 15 minutes. You needn't use all of your time. We have read everything. My best advice is that you get right to the point. With that, I'll call our first case, 24P889, Commonwealth versus TERILLI. Mr. Gasila, did I get that close?
May it please the court, my name is Kevin Gasilla, and I represent the defendant, the appellant, Mr. Terelli. Mr. Terelli is entitled to a new trial because omissions in the judge's response to jury questions about lesser included offenses of assault, battery. They didn't actually ask that. They asked about a body part, but he omitted to give that instruction. And also prejudicial error was caused when he decided not to give the specific unanimity instruction. The failure to instruct the jury that they explicitly must find the separate and distinct acts for each element of those crimes created a substantial risk of miscarriage of justice. The miscarriage of justice, I'll get that from Commonwealth v. Black, and the evidence must satisfy each element of the statute. And here, we don't have that. When those jurors went back into the jury room, right, we don't know how they mixed and matched the facts from that came in to evidence to each of those crimes, or how they did that. And when he didn't give the lesser included instruction...
Can I just interrupt for a moment?
Excuse me?
It's Judge Hinkle, correct? Judge Hinkle was the trial
Yeah,
judge?
Judge Hinkle, yes.
Judge Marianne Hinkle,
Yeah.
correct?
Yes, correct.
Okay, so 6 times you've referred to the judge as a male.
Okay.
Judge is a female.
I'm having trouble hearing.
The judge
Yes.
continues to be a female.
Oh, okay.
Thank you. Just,
I'm sorry about that.
it's okay. It's,
Nervous.
all right.
Okay. What I was pointing out, though, is that when they got into the jury room, they had to mix and match from the evidence, right? Because, and they didn't have, I'll do the lesser included instruction first. That removed that from their consideration. One of the questions that they asked was about a body part, right? And you also had evidence coming in about the steering wheel, the window, brim of the hat, though that probably wasn't it, but it's there. Fists, choking, this is all going on.
The judge did tell them that a body part could not be the dangerous weapon, though, right?
Right. But at that point, if one of the jurors was considering, okay, he committed a crime when he hit her with a fist, right? But I don't think that window part was it. Then that should have been a lesser included offense right there. That would be the assault, all right? That's a lesser included offense, and that instruction should have been given. Usually, that's given upon request, right? And here, defense counsel did not request it.
Do you have a case where this court or the SJC reversed a conviction because a judge did not sua sponte give a lesser included instruction?
I don't have a case on the reversal. However, there's a warning about that in Com v. Berry about that you should sua sponte, give the instruction to prevent this from happening. And I think this case is it.
Commonwealth versus Christopher Berry? Is it an SJC case from like the 90s?
Yeah, Comey Berry, 431 Mass, 326, 2000. Yes, if the defense didn't made a strategic decision not to ask, right? But if it becomes manifestly unreasonable that they didn't do that, then the judge may want to give it sua sponte to prevent a reversal.
Well,
I think that's what we have here.
Wasn't Mr. Terelli's defense is that it didn't, the acts didn't occur at all? That he committed no assault?
That's not what the claim.
He said he did assault her a little?
His defense actually was that she was not credible.
Right,
So that
meaning that it did not occur, excuse me,
strategic.
meaning that it did not occur.
Right, that was.
So a lesser included instruction would have run contrary to his defense.
Well, in one way you could frame it that way, but not really, because he's saying innocent. They're saying he did this assault and battery dangerous weapon, right? Right. But there's a range here, and you remove that middle range when you don't give the instruction. Now you've got all or nothing, right? And if the jury is correct in thinking that it's an assault, but not an assault and battery dangerous weapon, they don't have that anymore. That's why it's not. It's only as inconsistent as being found guilty. See what I mean? It's inconsistent with being not guilty, but that's it. So is the conviction that he got.
You know, there seems to be, I'm seeing kind of a common thread in both of your arguments, and you're looking for the judge, whether it's a specific unanimity instruction or a lesser included offense, you're looking for some precision.
Yes.
But doesn't confusion generally benefit the defendant? Because the burden of proof is on the Commonwealth, and if the Commonwealth hasn't made clear what the evidence is or how the evidence is connected to the charges, then that's going to run to the benefit of the defendant with the verdict, right?
I think at trial that usually would be the way it works. However, in this case, right, where they need to match the specific acts that are alleged or that came into evidence, not just alleged, that came into evidence with the specific crime, elements of the crime, right? That's where the specific unanimity instruction needed to come in here. Because
Well, can I interrupt for a moment? That's not necessarily true, correct? So the
it is because they have two, and there's other cases where, say, continuous actions with one accused crime, right? And you could match them all together. But here we have different actions happening over this period of time with two charges. The two charges makes a difference, right? Because you have to match them to the elements of the crime.
So the specific unanimity
we don't know what the
charge.
jury did. We could have 5 going, sorry, I spoke over you.
I probably interrupted you first. But the specific unanimity charge is only required if we were to determine, based upon the facts, that this wasn't one continuing course of conduct, right?
I don't think that's necessarily true in this case. I think we have a number of acts that you have to line up to each element of each crime here, even if those were all done in one short period, one course. Although I don't know that that's the exact, that you would conclude that. You could conclude that from these facts, or you could go the other way. But even if it was just one long series of different acts happening. You still have to match them up to the elements of the crime. And here we do have...
Have a case citation for that? Because my understanding is that if it's a continuing course of conduct, that the specific unanimity charge instruction is not required.
So, yes, so in Conifrey, and that quotes Sanderson, right? The specific unanimity instruction is not necessary unless a count is extremely complex. This probably for us, maybe not. For juror, it's going to be complex. I don't know about that extremely. That's subjective. But there is a variance between the indictment and the proof at trial. We have that here, right? And when they made the complaint, they put in steering wheel. When the evidence comes in at trial, right, steering wheel's in there along with a number of other things. In their closing, they never point this out. The judge talks about that when they were talking about giving this instruction or not. She asked about that. She pointed out that it was never discussed. So from this case, we actually have that. And there's a tangible, the last one part of that case, Conifrey, was there is a tangible risk of confusion. When those jury questions come in, we have that confusion here. When you look at the three of them together, we don't know what was going on, and it's in the trial transcript, the discussion between the attorneys, the clerk, and the judge. We can see they're trying to guess what's going on in that jury room, and they can't tell. A specific unanimity instruction may have cleared this up.
Well, let me ask you this, just to change the facts a little bit. What if you had a situation where it's a barroom fight that breaks out, and that one patron strikes another patron in the face, and then continues to strike him in the chest, and then they roll around on the floor and they end up being out on the street, and he strikes him again, he strikes him in the shoulder and strikes him in the stomach, and the charge is assault and battery. Are you saying that either one, jurors all have to agree on which strike constituted the assault and battery, or two, that the Commonwealth has to bring a separate complaint for each strike to make it clear?
No, it doesn't go that far. It wouldn't reach that far. And that would be different than what we actually have here.
Isn't that the same as what we have here? I mean, it's one continuous course of conduct, isn't it?
Well, for the assault and battery, we need a weapon, right? It can't be the fist. What was it? We don't know. And did three jurors pick one thing, 9 the other? However it is, we don't know. So we don't know if they ever came to a unanimous decision in that jury room, whether they actually convicted him unanimously. In your example, I think that would be just the strikes are all go to assault, and that element would be met. But if you wanted to do 2 charges on that, then you would have to differentiate, okay, which were the assault, or which group were the assault, and which was assault, say, deadly weapon, or which was the assault, whatever other way you wanted to charge that. Then you would need a more specific instruction.
Was there a request for a bill of particulars? Was there a request for a bill of particulars?
There was a request for a specific unanimity instruction.
But no request for a bill of particulars?
A what?
Bill of particulars.
No, there wasn't. Not in the record.
Okay, thank you very much.
Thank you.
Mr. Blatchford. I don't have a trapdoor button.
Good morning. My name is Howard Blatchford. May it please the court. I'm an assistant district attorney in Middlesex on behalf of the Commonwealth. 2 issues here. One, should a lesser included offense instruction have been given? Apart from the fact that there was no request for such an instruction, it would have been inconsistent with the defense presented at trial. The defense counsel argued during closing argument that the defendant should be acquitted because the evidence was at best inconclusive. The testimony was inconsistent, the photographs of the victim were unclear, and that the victim's motive had to do with the domestic relations proceeding. That was the defense. There was no distinction drawn in the defense closing argument between whether this was a simple assault and battery or an assault and battery with a dangerous weapon. As far as specific unanimity is concerned...
Before you get there, can I ask you, you said the jury, in support of your argument that a lesser included wasn't required, you said the jury was required to reach the highest verdict, which is true, but they only had one choice, well, they could choose not guilty, I'm sure, but they only could choose assault and battery, dangerous weapon.
Well, they could choose assault and battery. He hit her with a fist.
They weren't instructed on that.
Excuse me?
They were not instructed on the lesser included.
They were not instructed on the lesser included. That's correct. And it was not argued by the defendant that this was...
No, I understand that, but you argued in your brief that there wasn't a harm here because the jury was required to render the highest verdict, and the only choice for a verdict of guilty was assault and battery, dangerous weapon.
Correct.
So there wasn't anything higher or lower.
Correct.
That was it.
That was it.
So how does that help you?
I think that the fact that the defense counsel argued did not draw any distinction between either offense suggests that it was an all-or-nothing defense, that the witnesses could not be believed, and that the Commonwealth had not met its burden of proof for that reason. That was the sole defense asserted. Concerning the specific unanimity instruction, again, as the court's already noted, there's a substantial body of case law indicating that where there is a continuous series of events constituting, in effect, one episode, that the specific unanimity instruction is not required. I believe that the case attached in the addendum, the Spada case, is instructive and reflective of that. In that case, there was during one evening, approximately 30 minutes to 1 hour, several assaults committed, and the court found that there was no need to give a specific unanimity instruction there. Contrasting those facts with those of the Conferee case, where there was 8 incidents that occurred at 3 locations over the course of several days. Here we had one course of conduct over 30 minutes during one car ride. All of the conduct occurred within the confines of the passenger compartment of the car. And the dangerous weapon that was asserted both in the closing argument of defense counsel and in the Commonwealth's closing argument was the steering wheel. To be sure, there was also testimony concerning the defendant having pushed the victim's head against the interior of the door frame of the car. But I would argue that the interior of the passenger compartment would meet the definition of a dangerous weapon in any event. It was all confined in one location. These were items which are innocuous in their ordinary use, but become a dangerous weapon when they're used as such.
Well, at the beginning of the trial, the clerk reads the complaint, and in it, it makes clear that the defendant did, by means of a dangerous weapon, a steering wheel, assault and beat the victim in violation, blah, blah, blah. So the jurors are made aware at the very beginning of the case that the dangerous weapon is the steering wheel.
Correct.
Right? Okay.
Correct. Unless there are further questions, the Commonwealth would rely on its brief.
Done. Thank you. Thank you
Thank you.
both. We'll take it under advisement. The next case is 24P1, Commonwealth versus Winarski. Mr. Benyon, welcome back.
Good morning to the presiding justice, and may it please the court. We seek reversal of the new and a new trial based on 3 independent errors reviewed where unpreserved for whether they created a substantial risk of a miscarriage of justice. Number 1, the admission of an unauthenticated telephone "I'm sorry" statement. 2, the admission of an unauthenticated Facebook screenshot. And 3, prejudicial eve of trial amendment of the indictment dates undermining the alibi-driven defense. Cumulatively, these errors impaired the fairness of trial. And with your permission, I'll just go through each of the arguments, starting with the "I'm sorry" statement. The Commonwealth elicited the "I'm sorry" statement for what I'm sorry for what I did" statement through the complainant's parents without adequate voice identification or confirming circumstances to authenticate the speaker under Section 901. The parents lacked prior familiarity with the defendant, his voice, and records include uncertainty as to even who answered the call. Now, anybody could have had access if you believe that the call originated from the defendant, but there's no phone number, and so this could have come from anybody, including
He called the victim's cell phone number and the mother took it away, right?
That was one, yeah.
Yeah.
That was the main way that
Right.
I read the transcript, that's right.
And because there was no request to authenticate, there was no reason for the Commonwealth to ask if she recognized the defendant's voice.
Defense counsel did not ask, yes. Did not object. So we're looking at a substantial risk of miscarriage of justice. But again,
So he apologizes for what he has done to the victim. He doesn't deny who he is or that he did anything, or what are you talking about?
no, there's nothing like that. It's my client is upset that a statement came in that is an admission,
Yes.
essentially.
Yes.
Now, if you look at it that way, now, again, we don't know if this is the defendant calling. He didn't testify. And so the problem is when you have a phone call, you need to authenticate who's on the phone. Oftentimes this comes through, oh, did you recognize the number? Did you recognize the voice? We have nothing of that sort here.
Or there are circumstances that confirm the identity of the caller.
Yeah, but this takes place the next day. There's no indication as to the mental capacity of the young woman. She seems to presume that it could be Winarski, but it might not be. It could be her boyfriend.
She doesn't say that, though.
She doesn't say what?
She doesn't say that it could be her boyfriend.
No, I'm just saying that there are other people who could have called, who could have apologized, which is one of the reasons why authentication is an important step.
Someone else could have apologized for assaulting the victim?
Well, it just says, I'm sorry. It doesn't go into any detail, right? So
What I did to EM.
if it's when you take the statement with her testimony that you create this admission scenario. All we know is what was said on the phone, but we don't have any authenticating circumstances, and that is the problem here.
So you agree with me that the case law is clear that even if the witness testifying doesn't recognize the caller on the other end, the voice, can't say with any familiarity that there can be confirming circumstances to authenticate sufficient to get to a jury, correct?
I will agree with you, Justice Walsh, yes.
Well, that might be the one for the day, right?
No, I don't think so.
So there can be situations. In here, the victim knew your client, correct?
Yes.
Okay. Was familiar with his voice, correct?
Yes.
Okay, and had claimed and alleged that she had been raped by him.
Yes.
Okay, the night before. So why isn't confirming circumstances, why aren't they sufficient when victim tells mom, I'm talking to the defendant? he called me. Mom grabs a phone, so now victim, who's familiar with the voice and with the defendant, and says, this is who I'm speaking to, and then mom hears the defendant, or the person on the other end of the call, I should be more specific, say, I'm sorry for what I did to the victim. That under the case law, that's not sufficient confirming circumstances to authenticate that the caller was the defendant.
In this case, our argument is that it is not,
Right.
because you have to look at the case as a whole. Let me tell you some of the problems that at least I see. The testimony that comes out is 6 years, when at trial, it's 6 years plus after the event. People's memory changes. I think that's one of the reasons why it was difficult to remember exactly how the phone call went down. But again, the main point seems to be that the daughter answered and the mother grabs the phone from her.
Well, wait a minute, but that's not exactly right. If I'm reading the right part of the transcript on page 99 of volume 7, it says, did you hear from the defendant that day? Yes, I did. In what fashion, by what means? Let me focus here. Did he call on the phone? Yes, he did. Why isn't that authentication? He called. It was him. I mean, you don't need someone to say, did you recognize his voice? Yes, I did. He asked, did he call? Yes, he did.
I'm going to actually stop you there and say that, no, I think those points are actually important, because when you start glossing over questions like, do you recognize this defendant's voice? Was this the defendant's voice that you heard? Did you recognize the number that was called or that popped up on your phone? These are important points that allow, that impress upon not only the witness but the jury that the witness knows what they're talking about. Oftentimes in the back and forth between an attorney and a witness during a direct examination, you get in kind of and sometimes they get into a leading role where the witness is led, and sometimes it's just often presumed what the answer is. But as lawyers, we should be concerned with precision, we should be concerned with rules, and there is a very good reason why certain questions like, are you familiar with his voice? How are you familiar with his voice? How long have you known the defendant? Have you ever spoken with him on the phone before? Did you recognize his voice when he called, or was this just something that you assumed based on the context that this was Mr. Winarski when it might not have been? So I think that precision is important in these types of cases, and I think the case law bears that out, especially older cases that talk about these types of authentication calls.
Well, let me ask you about the Loach case, because that caught my eye. In that case, the person who received the call, the victim, disclaimed knowing who the caller was. And yet, that was still authenticated through the confirmatory circumstances of the call.
Again, that is true. But again, it's not whether evidence is good or bad, it's how evidence is brought in that's important. And that's my point. And sometimes case law can often gloss over the point that I'm making here and just kind of rush to the end. But in this point, what I'm looking for and what my client was looking for is something more something more to authenticate who was on the phone, rather than. And I think his problem is that the leading questions that were asked just kind of presume that he's the person on the call. If you presume that he's on the call and it says the caller says I'm sorry, well then that's an admission, and that's a problem. If you look at the case as a whole, again, this is more than 6 years after the events, and that is a problem, especially as we'll get into the alibi defense in the third argument. But the difficulty here is the time that has gone past. Memory is not great. I think we all know that. We often get experts that talk about that. So,
But as it came in, this is the first call is the day after the assault, right?
it is.
and he's expressing contrition for having assaulted
If you believe
the
it's him
victim.
on the phone, yes.
Yeah, so, I mean, that seems like a pretty powerful confirmatory circumstance. that
It could be.
What Justice Hodgens had read, that it was him on the phone, and then the mother takes the phone away, and he expresses contrition.
It could be.
Those are very strong confirmatory circumstances. In the second phone call, the mother calls him,
Yes.
right? And he again expresses contrition for having assaulted the victim.
Again, she's likely provided a number by the daughter. We don't know if that is Mr. Winiarski's number that she calls.
Is there any evidence that when he answered the phone call, he said, "Who are you? I don't know what you're talking about. You have the wrong number"?
I'm sorry, the first part of that, was that what he said, or?
Yeah, was there any evidence that he denied being the defendant when the phone call
No
from the
evidence
mother
of
was
that.
placed to him? Isn't that a strong confirmatory circumstance?
If you believe it's him on the phone. And it could
He
be. And,
didn't, but my point is, there's no countervailing circumstance that it was not him. He answered the phone, he didn't say, "No, you have the wrong number. I don't know who EM is." None of that occurred.
that is true. If you believe it's Mr. Winiarski, and he did not testify at trial, but he expects more through due process to authenticate who's on the phone. And that's the point. And I think his problem is this is taking place so long afterwards that the defense really was inhibited from really putting on a good defense, because when you have such a time gap, people who could be good witnesses for you, for your defense, might have forgotten what happened or what occurred, whether a phone call even occurred or not. And again, that's one of the problems.
But delays in cases rarely, if ever, inure to the benefit of the Commonwealth.
They certainly don't benefit a defendant.
Well, people's memories fade. You've told us already.
Yeah, but the problem here is that we're not dealing with some assault and battery. This is a sexual abuse of a child, and this often invokes real passion among jurors who might want to make sure that they're not letting a guilty person go. And that's one of the problems with these cases. And that's one of the problems with the time lapse.
Did you want to address any other issues?
Sure. The second issue, let's talk about the screenshot. This, my client feels, is a screenshot of exhibit which is in the appendix of the young woman, the complainant who put this in. It does not look like it's from the keeper of the records. He feels this is doctored. There is some language from the Connecticut State Supreme Court that I put in that really talks about the importance of authenticating these types of shots, because they can be doctored electronically. If you look, this is a screenshot of a browser. It says, how do you take a screenshot on one of the tabs?
And it's got the defendant's full name on it, right?
It does,
And it arrives 12 hours after the incident.
according to the exhibit, yes.
And all it says is that he hopes she got home okay.
Yes.
And no one's denying that she was there, right?
I think my client might want me to say that he denies that she was there, or that
Was there evidence that that there was any conflict in the evidence as to whether they were together that night?
No, they were definitely
Then
at that party.
how is he harmed by something innocuous as saying, "I hope she got home okay"?
Because I don't think this is innocuous. This is kind of one of those corroborating events. She says that he...
It corroborates
Yes.
something that wasn't in dispute, that she was there. He doesn't say, "I'm sorry I assaulted you," on the Facebook post, right?
Right,
He just said, "I hope you got home okay."
yes.
And there was a lot of alcohol consumed that night, right?
Yes, there was.
It could be genuine concern for her well-being.
Yes, but the government was putting it in to show that he was messaging her, and it wasn't just, whether you got home last night. I think one of the problems was the maniacal comment does not reflect well on the defendant, and that's a problem. If you're going to put in a record, it needs to be authenticated the same as a phone call. And this record, he feels, is not from the keeper of the records. It could have been doctored, and it supports the government's timeline of events. So it's part of the evidence that was against him. Last, with respect to the error of the amending of the indictments.
We're gonna have to leave it there, Mr. Binion.
That is it.
Thank you.
Thank you.
Mr. Lynn.
Good morning, Your Honors. May it please the Court. Paul Lynn for the Commonwealth. As Your Honors have already pointed out, this was a case in which this evidence came to the jury without objection, without a request to have it further authenticated. The victim specifically testified, albeit in response to a leading question, that this was the defendant who called her, and that her mother took the phone, and then the defendant apologized to her mother. And the mother's testimony was slightly different, that she picked up the phone, but she said, I think I picked up the phone, I think I took the call. And says the same thing, that the defendant says, I'm sorry. And that's the extent of that. It's in the context of the case as a whole, not only properly admitted evidence, but also it pales in comparison to the evidence from the victim and Michelle, the other woman who was involved in the assault, that there was a sexual assault that night. As for the alibi defense, that the Commonwealth moved to, excuse me a second, the Commonwealth moved to amend the charges 11 months before this trial, and the defendant admits at trial that once he got this confirming evidence from Michelle, he knew that this was his defense, that he wasn't involved with anything on Saturday, no longer had any weight, and so therefore he did not object to the amendment of the charges. The time of the offense is not an element of the offense, so in that circumstance, there could not have been a miscarriage of justice. Otherwise, unless this court has questions, the Commonwealth will rest on its brief.
Seeing none, thank you. Thank you both. The next case is 24P382, Commonwealth versus Reyes. Ms. Peterson.
May it please the Court. Good morning, Your Honors. Jennifer Peterson on behalf of Mr. Reyes. If I may, Your Honors, I'd like to begin with the argument regarding the grand jury proceedings. Your Honors, in the instant case, the integrity of the grand jury proceedings was severely impaired by a highly misleading presentation to the grand jury. That presentation consisted of roughly 13 pages of testimony by Officer Arsenault, as well as 4 exhibits, 2 of them explicit videos, one of which was involving a tree and the outdoors and had no metadata, the other taking place in a motor vehicle and did have metadata indicating that the complainant was 16 years old at the time that videotape was taken. Now, the other 2 exhibits were some photographs, some screenshots that the complainant provided the Commonwealth, as well as the police interview of Mr. Reyes. So with respect to the graphic videos, the Commonwealth was well aware that the complainant was 16 years old and thus of age at the time of the video that was taken in the motor vehicle. And while that may have been relevant with respect to some of the other charges and the indictments that were requested, with respect to statutory rape charge, the Commonwealth knew that that didn't take place.
That's not the way that I read the record at all.
Okay.
So that might be an argument at trial, but the way that I read the record is that the victim clearly testified. She didn't have a specific memory of when or where, but that she was 15 and she was out in the woods when she had intercourse with the defendant.
Yes, that's with respect to the first video, the tree video in the woods. However, the second video that was in Duxbury, the officer even references that it was in Duxbury, suggesting, she was well aware of the metadata that was associated with it, and she was also well aware of the complainant's age, and knew that that second video...
Wasn't the second stat rape indictment dismissed prior to trial?
Yes, it was, but I would suggest that that's not dispositive of the issue here. I think, in fact, that supports the argument that the Commonwealth shouldn't have requested it to begin with and shouldn't have implied to jurors.
There are other charges here besides the rape of a child, right? There's dissemination of pornographic materials to a minor.
Yes.
So, what, I mean, that could occur with someone who is 16, yes?
Yes, certainly, Your Honor. And we don't quarrel with the introduction of it. What the problem is that the Commonwealth failed to disclose the highly relevant fact that this videotape did not depict a life felony. It was a consensual act. So, and to withhold that information from the grand jury, I suggest, is misleading.
Well, I don't read the grand jury minutes the same way. I'm looking at page 11 of the grand jury minutes. The prosecutor actually said, but again, the incident in the woods and one of the incidents in the car, she is the age of 15. Is that right? And then the answer is correct. So it seemed that the prosecutor did make an effort to distinguish the two videos.
I think the Commonwealth played fast and loose and parsed quite a bit in this grand jury presentation. And I agree that she did sort of cover her bases by alluding briefly to the fact that there may have been more than one incident in the vehicle. However, the grand jurors had the right to know this is exculpatory information, and the way that the request was made, they presented two videos. They wanted 2 counts of statutory rape, 2 counts of possession, 2 counts of dissemination, and 2 counts of posing. So it was clear that they were essentially lining these up in parallels. And with respect to the statutory rape, the second statutory rape, that was misleading. And throwing in, well, there may have been other times, in passing, the clear implication is that the jurors are being given 2 videotapes that depict 2 statutory rapes, whereas the Commonwealth and the witness both knew that that second videotape did not depict statutory rape. It was consensual sex between the parties. So that, I believe, is severely misleading. The prosecutor, I would suggest, according to the case law, has an obligation to bring potentially exculpatory information to the grand jury. And the prosecutor here...
Well, I disagree with that. What case says that? Doesn't the case law actually say the opposite of that? That there is no obligation to present exculpatory evidence?
I don't believe they have an obligation not to mislead and to clear up if there is anything that's misleading. And I think this is misleading. And I think they have, let's see, I have some language in my brief that suggests that they do, in these sorts of circumstances, they do have an obligation to be clear and to not mislead the jury. And I believe that's exactly what they did with respect to that. And
you also have to show that they not only they were purposefully or knowingly and recklessly provided the information, but they did it for the purpose of obtaining the indictment, and it actually led to the indictment.
It did.
Well, but what evidence do you have of that, though? The indictment itself isn't evidence of that. It kind of helps if you... Do you remember what happened in Odell?
I don't know the exact facts. I don't recall
Well, in
them.
Odell, the defendant had made a statement to the police a good third of which was completely exculpatory. And when the police officer read the report to the grand jury, he omitted all of the exculpatory things the defendant said. That was purposeful, and that was misleading, and that caused them to indict him for the armed robbery of the store.
And here, the Commonwealth was well aware that this particular video showed a consensual act that was not statutory rape, while asking for the grand jury to issue.
The victim told Arsenal that they engaged in sexual conduct on numerous occasions, and that she was 15 on some of those occasions.
Yes, and I agree that that was kind of vaguely referred to, but there's no doubt a fair reading of these 13 pages of testimony suggest that this videotape correlates with the request. And I would suggest that's why it ultimately got dismissed by the Commonwealth, because the Commonwealth was
But why wasn't it relevant to the dissemination charge?
I'm not saying it wasn't relevant to the dissemination charge.
So you're saying that they can't put in evidence relevant to another indictment because it might have coincidentally influenced their decision on a separate indictment?
No, I'm not saying that, Your Honor. I'm saying that the Commonwealth had an obligation to be transparent with respect to the nature of this. The Commonwealth should have made it clear that even though that this is a videotape that they're showing, this does not represent an incidence of statutory rape. Rather, this was taken when the complainant was 16 years old, and therefore it wasn't statutory rape. So I think jurors should have been apprised of that fact, and this is a fact that may have affected their decision to issue 2 indictments as opposed to 1 indictment for statutory rape, because we don't know whether or not the jurors would have credited the, oh, and she said in her saying that this may have happened more than once. We don't know if the jurors would have credited that. What we do know is that they saw this explicit graphic video, and they were told it took place in Duxbury, but were not told that it took place after the complainant's 16th birthday. So it was not an example of statutory rape. Is that withholding, that deliberate withholding? You ask how we can know it was intentional? Well, they talked about Duxbury, and they didn't talk about, you know, the fact that she was 16 when it took place. And on top of that, how we can know it's intentional is the other 2 issues that took place. The phone extraction.
Wait a minute, let me just, before you go there, let me just go back to this, because Justice Meade raises a good point about, was it done with an intent to procure an indictment that you otherwise wouldn't get? At the end of the testimony of this officer, she's asked, and at any point in time, now the defendant has given a statement to the police, he's admitted that he has had sexual relations with her, and at any point in time, did the defendant indicate that he knew she was only 15? Yes. When is that? At the end of the interview.
And that's patently false, Your Honor. Have you read the interview? If you've read the interview, you know, he doesn't say that at all. That's not what the interview says. The interview shows Officer Arsenal trying to confuse him as to when this took place, and ultimately getting him to admit, yeah, it happened before COVID, so you're saying it happened in March. All she did is confuse. He never admitted he had sex with her. In fact, he spent the majority first saying he doesn't really remember, and then saying he didn't really know what her age was. There's nothing, and I've read and reread and quadruple read this, and things like, you know, it happened so long ago. And do you think it was back in March when COVID started? Earlier than that or later than that? I think, honestly, it was sometime, okay, so in 2020, how about that? Do you remember the weather? Was it cold? Was it warm? I really don't remember that well. And then he says, I think when we met, when I met her, COVID hadn't come out yet. I'm pretty sure, but again, I don't know. Were you sure? That was way before that. Was it probably 2019? No, I don't want to say that. I don't want to say that. I really don't effing know. Whatever you have, right? He doesn't know. That's what he says. He doesn't say, oh yeah, I knew I was having sex with her when she was 15. Didn't happen, not in this transcript. So I think that is a deliberate misrepresentation, and that's another way that they...
Let me ask you one other question about the exhibits. So would you, because you raised this issue about the state of nudity and so forth, would you agree that the victim was depicted in a state of nudity in the exhibits to the grand jury?
I believe so.
Okay.
Yes. Yes. I haven't examined the actual ones, but based on my reading of I didn't review the videotapes, but based on my review of the entire record, it's my understanding that's the case.
Okay.
With respect to the phone extraction, once again, you know, they played fast and loose with that. They suggested that there had been Mr. Reyes' phone was forensically examined, and I don't believe even though they say there were videos, and even though at one point the Commonwealth references at sidebar that one of the two incidents, the video of one of the two incidents was on his phone, that was never introduced to either the grand jury or at trial. And what they did at the grand jury, however, which is what I'm trying to focus on here, is they suggested that there had been a forensic examination of the complainant's phone, which absolutely didn't happen. She refused to give her phone, absolutely refused. The only reason that they had those videos and any screenshots was the videos and screenshots she decided would, quote unquote, make good evidence. She forwarded them to the Commonwealth and refused to allow them to have her phone. Despite that, they say the evidence, quote unquote, they use the phrase evidence, was taken from her phone. And they clumped it together with the discussion about the forensic examination of Mr. Reyes' phone, and where they said that several videos were found, seemingly suggesting that it was these two videos that were being presented to the grand jury. But they don't say what the videos are. They didn't introduce the Cellbrite thing. And even as far as the motion to dismiss, I'm not aware that there was any proof that this particular, either of these videos was on Mr. Reyes's phone, as proven by the extraction. And then there's the whole incident of the 15 text message. The implication that she told him that she was 15. That conversation, the text conversation back and forth, I've printed it up in my brief, but it clearly seems to be about buying and selling drugs. So any numbers that are in there, and it seemed to be about the pricing and amounts of drugs. It doesn't seem to have anything to do with her age. The only thing I think that had to do with his knowing that she was in school, which really doesn't go to his knowledge of her age, 15, 16, was a screenshot that he said, "Oh, I forgot you were in school." So at the end, I think that the evidence here was insufficient in general in front of the grand jury because it wasn't reasonably trustworthy. But the presentation was unfair and misleading. And it's not just one, it's a number of different issues. It's the graphic videos, it's the phone extraction, it's the text messages, and it's the parsing that's going on. This is a misleading presentation, and because of that, and the
All right, we're
courts
going to
are
have to
clear.
leave it there, Mrs. Peterson. Thank you.
Okay, thank you, Your Honors.
Mr. Hanson.
Thank you. If it pleases the court, Arne Hansen from the Plymouth County DA's office representing the Commonwealth of Massachusetts. With respect to the videos, I filed a motion to submit them to the court. Has the court seen the videos? Because I know I didn't transmit them to the court.
You're talking about part of the grand jury presentation?
Correct. So I put an appendices together that included the grand jury exhibits as well as the trial exhibits, and obviously the videos are important for the court to review because that's really the issue of the case here. And then I filed a motion with the court as to best address transferring that information to you because it is child pornography. Has the court taken any action on that?
No, I think it's still under advisement.
Okay.
But let me ask you the same question. So would you agree that the exhibits, because the officer never testified that the victim was depicted in a state of nudity, which kind of surprised me, but would you state that the exhibits presented to the grand jury do depict the victim in a state of nudity?
Yes.
Okay.
So the first video, it starts with the camera focused on the...
You don't have to describe it, it's just that I get it. It's just what I was looking for.
They're very obviously nude and they're very obviously having sex. Now, with respect to the misrepresentation to the grand jury, I think ADA Fowl made it very clear that there was a distinction between what was depicted in the Woods video, where they're having intercourse in the woods, and the car video. With respect to the Woods video, she prefaced it with, she's 15 at the time, before putting it in as an exhibit, and that's clearly on page 10 of the grand jury exhibit, record appendix 36. She's 15 at that point. Then she introduces the second exhibit, which is the video of them having intercourse in the car. And ADA Fowl, and I'm just going to read from the transcript, this is page 11 or record appendix 37. ADA Fowl asks, fair to say that these videos depict victim's name as a willing participant in the sexual activity that's going on. So again, she's using the term willing participant there. Suggest that's inferably not statutory rape because we know that she's 16 when that video is recorded because of the metadata. The officer Aronso says yes, and then she refers, ADA Fowl refers back to the Woods incident and said, she's 15 at this point, correct? And clearly she's drawing a distinction between the two. Notwithstanding that distinction, the metadata is in Exhibit 2. So there's 3 documents on the disk that is Exhibit 2. It's the actual video of the intercourse, it's the metadata which shows that the video is recorded after the victim's 16th birthday, and the grand jury knew the victim's date of birth because that was put into the evidence as well. So the grand jury had all that information, and ADA Fowl goes on record and states, you have a computer in the room, you're able to review all this data independently. So the grand jury certainly had the resources to evaluate that. So I don't think there's any deception for any reason there, and I think she made a clear distinction between the two, notwithstanding the fact that all of this evidence was still relevant for the other 6 charges, that being the creation, dissemination, and possession of child pornography. So it certainly had bearing to those charges and wasn't just thrown in to try to obtain this indictment.
Was there a reason not to put in evidence of the victim's date of birth? That might have made it pretty clear to the grand jurors what her age was during these incidents.
I thought her date of birth was put in before the grand jury.
I didn't see it. If it's there, I'll take another look, but...
Then I'm not sure why that wouldn't have been put in.
So even if the date of birth was not put in, I mean, it would be very clear, as she did with the Woods video, to say, and she was 15 at the time of this video, correct? Yes, she was 15, and submit that. And at the second video, to say, she was 16 at this time? But that didn't happen, correct?
Correct.
You want us to say it was clear to grand jurors, that the words willingly, a grand juror would understand that to mean that she was 16. Is that what you want?
I think that's a reasonable inference that can be drawn from
You think that's a clear? I mean, what I heard you say is that was clear to the grand jury.
Yes.
The words willingly. You want me to trust that grand jurors would understand on the first one, if she's 15, instead of saying she was 16 when this video happened, that it was clear by the word in the question that she willingly engaged in intercourse.
I agree with Your Honor. Certainly phrasing it that way would have made it a lot substantially clearer, but I do think that she did enough to separate those 2 videos in terms of age.
And I guess my point is that our analysis doesn't kind of form the basis of whether a better job could have been done at the grand jury or whether certain evidence would have been nice if it was there. The question is whether it was misleading.
Right.
Right? And intentionally brought with the purpose of obtaining an indictment.
Right, and I don't believe that's the case here at all. I think ADA Fowl is putting in that video second because then she moves on to the other charges and immediately after starts talking about age of consent to create the pornographic material. And I think that's why it's relevant. Notwithstanding the fact that charge was dismissed prior to this motion ever being filed, so the issue was moot before the Superior Court before it was ever raised. Does the court have any additional questions?
Yeah, how about the issue at the end where the officer testifies that the defendant acknowledged his sexual relationship with the victim, and then at any point in time, did the defendant indicate he knew she was only 15? Yes. When is that? At the end of the interview. Now, defense counsel is saying that that's a complete misrepresentation of what the actual statement was. What do you say to that?
So he does admit on 2 occasions, so it's defendant's record 42 and 79, that he had intercourse with the victim, and he admits that he had intercourse with the victim in his car. I cannot find the reference to he knew that she was 15 at the time. So I did not see that in my review of the record. So that does appear to be an error. I would say it's not dispositive of the issue here because the full video of the defendant's interview was put in before the grand jury, so they had an opportunity to view that interview. They didn't have to rely on the statements of Officer Aaron, so they're not, so that would be the extent of my argument with regards to that.
Let me just ask you this as a practical matter, because these grand jurors, you know, they're sitting for long periods of time to hear every case that comes into the Superior Court during that period. And if you just mark something as an exhibit without playing it for them in the grand jury, how do we know they looked at it?
We don't.
Well, it's not very helpful, is it?
No.
Okay.
Are there any other questions?
Seeing none, thank you. Thank you
Thank
both.
you.
We'll take it under advisement. That'll call to a close today's session. I'd like to thank my panel, our law clerks, our court officers, our court staff, and our excellent timekeeper, and we will stand in recess.
All rise.